Welcome to Club E. Hi, I'm Rick Brimacombe of Brimacombe and Associates. I'm your architect of business growth and will work with you to unlock your potential and amplify the scale of your company. Today, we are talking about intellectual property 101. And with that, I would like to thank our sponsors, Irish Titan, an e-commerce and web development firm, Highland Bank, a locally owned community bank, Highland Bank, again, a locally owned community bank. They've been in business for over 75 years. And Romaine Berg, a digital marketing agency. Schwegman, Lumberg, Woosner, an intellectual property law firm. Voyager U, a catalytic gateway for building your independent work life. Please hit the subscribe and like button below. That will allow us to let you know when we are going live. And also a reminder that you can catch Club E on your favorite podcast platform. All right, with that, I'd like to introduce Lori Young, intellectual property attorney from Schwegman, Lumberg, Woosner. Contact information for Lori is in the comments field of YouTube. If you are listening, it's L as in Lori Young, as you might suspect the spelling to be, at slwip.com. So again, Al Young at slwip.com. And Lori, tell us a little bit about yourself, your background, the firm, and the various things that you are up to.
Sure. Hello, my name is Lori Young. I am an intellectual property attorney with, as was mentioned, Schwegman, Lumberg, and Woosner. I have been in practice for 14 years. I've been in-house for 10 years, and then I moved to Schwegman, Lumberg, and Woosner, and I was at a firm before I was in-house. I have a background in mechanical engineering and love anything that has to do with mechanical engineering, things that move, and especially the aerospace industry. However, the company that I was with was in the printer and copier business. So I've been doing a lot of printer and copier work for the last 10, 11 years. I live in Minnesota and a mom of two great little people.
Yeah. All right. And I am wondering, is there a tie between mechanical engineering and baking?
Only in that it is both scientific. Baking is a science. If you add too much liquid, your cookies will go flat. There are solids that form into liquids that you have to be aware of. There are chemical reactions that happen with either baking powder or baking soda. And you have to be very methodical about it.
All right. So that's kind of, so that's kind of where I was going, the being precise, methodical, stuff like that. So that was a little bit of a trick question. So Lori, you're quite the adept baker, both doing it for your family, your friends, coworkers, et cetera, but also submitting some of your cookies at the state fair. So tell us a little bit about your main hobby and why you got interested in that. Maybe it was something on the home front as a child, and B, all the different things that you're doing with it now.
Sure. So I've always told my mom the worst thing she ever taught me was how to bake, because it has sort of become an obsession. I currently am trying to bake my way through a King Arthur Flour cookie cookbook while simultaneously perfecting a recipe for the Minnesota State Fair baking competition. The state fair has, I want to say, about 20 different cookie categories that you can enter. And so I pick one of those categories every year. And starting in about February, so after I have a little break from my holiday baking, I start working on perfecting a cookie recipe to enter into the fair.
And then obviously it's about the journey and the doing it and the rewards of the time spent in the kitchen. So it's not about the external accolades. However, you have participated in the state fair now for 10, 12 years, I think you may have mentioned. And then you also have won a few awards. So tell a little bit about how you did and what those recipes were.
Sure. So I did place first in one of the categories for a corn and bacon cookie. It was a corn sugar cookie with bacon crumbles. And I've placed fifth twice, one for my ginger cookie and one for a bananas Foster cookie, which was a banana cookie with a butter rum frosting.
Hmm. And is there a family favorite other than you with your husband and children? So is there one special recipe that they like the best?
Um, Everyone in my family, actually except for myself, loves my ginger cookie.
Okay.
I actually don't like molasses, and that's one of the main ingredients in a ginger cookie. So people fight over those cookies whenever I bake them.
All right, which is probably more rewarding than the ribbons at the state fair. I'm sure that's a fun thing to do.
Yeah, I love baking for other people. So when I do bake, very few of my cookies stay in my house. I just like the enjoyment that other people get from eating cookies.
Okay. So shifting gears to the work front, you've worked inside uh, as counsel in various corporate entities. You've worked as an adjunct trademark law professor, which actually law school is why you ended up coming to Minnesota from New
Mhm.
Orleans. And then now, as you mentioned, you've been at SLW, Schwegman Lumber Woosner for a number of years, an intellectual property law firm. How have you enjoyed that transition? And how did each step kind of build on the prior one leading up to what you're doing today?
Sure. So I moved to Minnesota to go to law school, and I went to William Mitchell. So it was William Mitchell at the time, now Mitchell Hamlin. And during my time at Mitchell, I only interned in-house, so a small startup and at Best Buy. And I then got a job at a law firm and realized that with that law firm, I was doing work for clients, but never really understanding the business behind it, and figured I should move in-house. So I moved in-house to Caton Corporation, where I was for a little bit over 10 years. And then I made the move to SLW because at Caton I was very pigeonholed in my technology and really wanted to diversify the technology that I was working on. So SLW offered me that opportunity where I still represent Caton, except from outside as outside counsel. So I still have my foot in the door with the business decisions and doing their intellectual property work. But I also work with several other clients around the country who help me to get my shift my mind so that I'm not always doing the same thing.
Sure. So, given that our topic today is intellectual property 101, let's just start with a couple of definitions.
Mhm.
So, tell our audience, what is intellectual property?
So I understand that everyone has a different understanding of intellectual property. And with that, to make it easier for those who may not understand, I'm going to help you build what I like to call an IP house. So we're going to set up the framework for the house and then build it on. There are technically four different types of intellectual property. You're probably aware of the first three, which are patents, trademarks, and copyrights. And the fourth, which I call the redheaded stepchild because not many people think of it, are trade secrets. Um, so we'll discuss each one of those in turn. And as you build your intellectual property house, I just want you to think about the things that you have in your house, whether it is your house is an apartment or a large mansion. You just need to lay the foundation and the framework for that. So we can start with. Should we start with patents?
Yeah, start with
Okay.
patent. So, tell everybody what a patent is.
So the formal definition of a patent is it's a grant of property right. So similar to your house is your property. A patent or any of the intellectual property are property rights and intangible property rights. A patent is a property right given to an inventor that is issued by a government entity. And it's the government entity where you're seeking protection. And that property right is only valid for a specific number of years. In the United States, your property right extends to the 50 states and any territory. And then it's only valid for 20 years from the filing of your application, not from the granting, from the filing of your application. So even if it takes, 4 or 5 years at the patent office, that take 20 years and subtract however long it's been going back and forth at the patent office. And that's how long you have your patent. I like to think of patents as the basement where you do your work, where your supplies are, your tools are, so that you are then creating, you're inventing something new and different. And patents are granted for inventors because they're new and useful machines, articles of machines, compositions of new matter, or improvements on something before that hasn't ever been done. So just some fun different patents that I've come across. Not in my profession, but if you are interested in random patents, I love the fact that there's a rodent blaster. So think of it as like your mouse trap with slingshot on it. And then another one, for those of us who are outdoorsy, there's a beer umbrella, which is an umbrella that you can put on your beer bottle so that your bottle doesn't get wet in the rain at a football game. So patents are for things like that, or patents could be for methods, such as a method for concealing partial baldness. So basically a method patent for the comb over. And then for those of you who are Michael Jackson fans, Michael Jackson actually has, or he has a patent application, or I'm sorry, a patent for the method of creating the anti-gravity illusion. So the way that he leans forward and then comes back up, he actually has a method patent for how that is done.
Who knew?
Yeah, those are just some fun patents out there.
Absolutely. So then you mentioned of the four aspects of intellectual property, patents being the first. Second one you mentioned was trademark. So tell the Club B audience, what is a trademark?
Sure. The technical term or the technical definition for a trademark is an indication of source of goods or services. It's the words, images, packaging, color, or sound associated with a good or service, or a business offering a good or service. I like to think of trademarks as your address. It lets you know, it lets others know where you are, and where your business is and what your business has. So a trademark is what is things like General Mills or Target and just those words, or a service like Geek Squad. And both of those, or all three of those, are well-known trademarks. So those are trademarks that have been filed with the U.S. Trademark Office. However, it could be something local and small business is a trademark as well. A trademark does not have to be nationally known. It just needs to be the words or images or associated products that are associated with your business.
Okay. So if the patent is the basement and the trademark is the address, the third thing is a copyright. What is a copyright and what's the analogy to your home concept?
Sure. So a copyright is where you have fun. And I like to think of a copyright or the definition for a copyright is the right that's given to an originator to print, publish, perform, film, record any literary or artistic or musical work that a person has created. Now, copyrights aren't always fun in that they're not necessarily related to a music or a book or something like that. They could be as simple as instructions or a business plan. A copyright is anything that you create that has been put in a tangible medium. Now, you may think a tangible medium is a piece of paper. However, copyrights have been extended into the digital age, and so that it's something that is non-transitory, meaning that it's not me performing in a room by myself. It's something that has been captured. So if you are having a party and you have your friends over, it's not your friend doing a quick stand-up sketch. However, if you record it, it becomes many different copyrighted works.
Okay, so the copyright where you have fun, kind of like the rec room, the family
Yeah.
room, the game room. And so then the fourth aspect of intellectual property, the trade secret. Tell everybody a little bit about trade secrets.
So trade secrets are like my cookie recipes. They do not get shared, and if they are shared, it's with extreme limitations. So it is an intellectual property right that's given to the information which you do not want disclosed to any other person who can use it for their own advantage. And the trade secrets actually have three specific elements. First, it is information that is not generally known to the public. So the public does not know my cookie recipe. It is a trade secret that confers an economic benefit to its holder because the information is not publicly known. So my cookie recipe is not a trade secret because it doesn't confer any economic benefit to me. I'm not trying to make any money off of my cookie recipes. It's just my hobby. And finally, the holder of the trade secret has to make reasonable efforts to maintain its secrecy. So I don't disclose it, even though I have it written down. I am not sharing it with other people. And actually, all my friends know that my state fair cookie recipes are not shared.
All right. So, but like the chocolate chip cookies out at the state fair, tying it in with you submitting your recipe, those where they have a business selling those chocolate chip cookies, their recipe would be a trade secret because of the economic benefit to the holder aspect, correct?
Exactly. I'm pretty sure that Sweet Martha is her cookie recipe is a trade secret, similar to Coca-Cola's formulation or Kentucky Fried Chicken's their spice combination. Those are trade secrets to those businesses.
Okay. So there are many business owners, entrepreneurs listening. Those folks have limited budgets, as do most companies, but certainly the smaller emerging companies up in the lower middle market. So with a limited budget, how should they allocate resources for their intellectual property?
Sure. First, I want everyone to think about what your business is, and not every business is inventing. And as an in-house IP attorney, I recognize that there are just sometimes not value in getting a patent, but every business is branded in some way. So I like to think that your first efforts should be in getting your brand protected. Similar to how all houses are different, a house could be a studio apartment for the person who just needs the basics, a place to sleep, a place to eat, a place to clean themselves. Or you could be a person that needs a 10,000 square foot mansion who needs to spread out and claim the most real estate because of what your business is doing. So, like I said, every business needs to be branded. So I would first spend your focus and time on making sure that you have that address. So people know where your business is and what your business is. And when I say what your business is, you also want to stay away from specifically using a trademark to define what your business is. So if you're in the business of selling cookies, you don't want to call your business the cookie shop. It's going to be harder to distinguish yourself from a competitor if you use a generic or descriptive trademark or business name. But just because I said that you should start with spending your IP budget in trademarking, I would also say that it's your IP time budget as well. So how much time do you have? You need to, I would start with spending your time budget on your trademark, because while you can get a registered trademark with the US Trademark Office, there are also what's known as common right trademarks, which are your business name or your product name just being used creates a common law trademark. And so you do not need to spend the money on getting a trademark registration immediately. You can test out the market for your product using that business name. However, this is where your IP time budget needs to be spent. You need to do what's known as a trademark search. And you can do a trademark search on your own using the US Patent and Trademark Office's database, because the last thing you want is to spend your time and investment into a brand or a product name that's already being used for the same or similar product. Similar to the way that when you buy a house, you want to do a title search. You want to make sure that the house that you are buying is yours, and not, some of your land is owned by your neighbor. You want to make sure that your trademark search is done. So you need to spend your time budget that way. Now, if you know that you really want to go ahead and sell your product outside of the state of Minnesota or outside of the state of Wisconsin, you might want to look at getting a registered trademark for that. So going through the process of filing the registration. And I would go ahead and spend that money because your brand and your business image is probably the most valuable asset, intangible asset you have to your business.
So that all makes sense. Again, as a business owner, advisor, board member, you always have to be aware of budgets and how you allocate resources and stuff like that. Are there any low-cost options in intellectual property law?
So not registering your trademark could be a low-cost option. Another low-cost option or area of intellectual property law is copyrights. Now, if you are in the industries of creating films or creating recordings or writing books, creating something that's actually the value to your business is in what you are creating, and it's an artistic work or it's an informative work, that's where you need to register your copyrights with the Copyright Office. However, most businesses that I've come across are not registering everything with the Copyright Office. They're not registering your instruction manuals. You're not registering really anything much advertisement that you may draft up. The creative works become creative, as I said in the introduction, the second that you put it into a tangible medium, or it's in a non-transitory format. So that's where you can create your works, and you don't necessarily need to register it. However, that doesn't mean that you shouldn't. It's just if you're a startup business and you're not in an artistic realm or a realm where the work that you are creating is of great value, then I would not necessarily focus my budget on registering copyrights. Because a copyright exists similar to a trademark in common law. The second that you create it, it's a copyrighted work. So the second that my child I record a video of my child being silly and singing a song that he made up, that's a copyrighted work, but I'm not going to go and register it. And similarly, in my business, we don't register every advertisement we create. If I was a large corporation and I had a copyright budget, I probably would think about it a little bit harder, but small to mid-sized companies rarely register their copyrights until it becomes necessary.
How about patents? Talk a little bit about where patents fall on this cost continuum.
And patents, to be honest, are the biggest financial commitment of all types of intellectual property. It's also the area where I always recommend hiring an IP professional. You do not want to get into a situation where you are filing your patent application yourself. There are just too many intricacies to US patent law or any patent law to have it done by yourself. I like to think of patents as the furnishings in your house. You can get away with sleeping in a sleeping bag or cooking in a microwave or using disposable products, but the furniture is a cost, and it's a cost that makes your house livable. And it's a huge upfront cost too. And yes, you may need to replace or repair furniture. You similarly want to spend that upfront cost if you are creating or I should say inventing. And if those inventions are going to be the core of your business. I'm only going to discuss US patent law right now because while there are global options, most entrepreneurs and small businesses I see are focused in the US. So getting a US patent is more valuable to you than getting a European patent or an Australian patent. You're going to want to just stick in the US. And while your patent rights don't extend outside, at least you have the protection in the United States. Now, with patents, there are two routes you can go. The first, and for most entrepreneurs and small businesses, this is a way that you probably want to think about strongly, is to file what's known as a provisional patent application. And this is a documentation that you can file to secure what's known as a priority date. So the date that your invention or your concept was created. And that date is a date of filing at the US Patent Office. The US is first to file. So that means that when you have that concept, you want to file it at the US Patent Office. I must put in the caveat that a provisional patent is only valid for 1 year. And what you need to do during that year is, if you are a small business, a patent application from an IP professional can easily be greater than $10,000. So you might want to take that year to get funding, or you might want to take that year to actually perfect your patent application or your concept, because typically within 2 months from that end of that 1 year term, your patent attorney is going to be calling you and on you to get your actual non-utility or your non-provisional or utility application filed. While I'm discussing the application or the provisional application and trying to go out to the public to get funding for the rest of your patent portfolio, I should also let you know that once you begin that invention process, the US has what's known as a statutory bar to patenting, which means that if you invent something, you have 1 year from the time you disclose it in public to get your utility patent application filed. So that means that if you invent a new mixer for cookies and you want to start marketing it, you have 1 year from the date that you disclosed it to the public to actually get your patent application filed. And that's similar for your for your provisional application. You have 1 year to get that filed. And it's really disclosing it to anyone outside your business. It could be to your partner, it could be to your best friend. If that becomes known that you disclosed it to anyone, then that statutory bar begins to run. And it can really bite you if you realize that, oh, wait, I actually did disclose it to a potential investor, 13 months ago. And you tell your patent attorney about that, which you will be obligated to. Your patent attorney will tell you, well, we can't we can't file an application on what you disclosed to your friend or any part of it, unless you've come up with a substantial new invention related to that within that 1 year. So just be aware of this 1 year bar. And a provisional patent application is a cheaper route to go to before you file, because a provisional patent application could be something as simple as an invention disclosure form or some PowerPoint slides, something like that. Or it could be you put the investment into getting a decent application drafted, which most patent attorneys would prefer rather than going back to a PowerPoint presentation or an invention disclosure form, because the more information that you can file up front on your invention, the better off you are to getting a full utility application drafted. Now, you do not have to file the provisional patent application. You can go straight to filing the utility application. And that would be having your patent attorney or other IP professional, because you could have a patent agent do it as well, put together your full patent application, which would include your specification, which described your patent or described your invention, your claims, which are the actual concept that you're trying to invent, plus the figures that need to go with it. And that would be filed with the US Patent Office. Now, you should also be aware that there are costs after filing your application.
I was just going to ask that. So yes. And the $10,000 cost, I mean, some of these patents are game changers for the company. So that might be the best $10,000 that a company ever spends. However, and you are going to just go there, that there are costs after the patent is granted. Talk a little bit about the maintenance fees.
Sure. There are maintenance fees that you have to pay, because as I said, your patent is valid for 20 years from filing. But that's only if you pay your maintenance fees. And there are 3 different windows where maintenance fees need to be paid. The first opens at 3.5 years, the second opens at 7.5 years, and the third is at 11.5 years. In each one of those, the fee to the US Patent Office increases. And it depends on whether you are what's known as a micro entity or a small business or a large company, as to what those fees would be. A small business is anything under 500 employees, and that's 500 employees globally. And a micro entity is more along the lines of your solo inventors. And obviously the micro entity has lower fees than your large corporation, as you would hope that, General Mills is paying a little bit more in their patent maintenance costs than your garage inventor.
Okay. So what should a business owner or executive try to avoid that may end up costing them money, and or are there mistakes that sometimes folks may make that you see?
Sure. And I'm not going to do a sales pitch, but really anything that you want to file with the USPTO, I would recommend hiring an IP professional. Only because there are horror stories, both on the trademark side and the patent side, about solo inventors or small businesses or individuals filing trademarks or patents on their own. A lot of times, the costs that you would have incurred filing it with an IP professional would actually be less than an IP professional trying to untangle, if they even can, the issues that you may address you may come into on the trademark side or the patent side, because you just weren't aware of a way that you needed to file something on the trademark side, or something you needed to put into your patent application on the patent side. And those costs can just keep increasing, because that's where your IP professional will be corresponding with the patent and trademark office and the people there. And each one of those correspondences will cost you money. But if you had an IP professional do it the first time, I'm not saying that they won't, your patent attorney or trademark attorney won't be corresponding with the office. It's just that at least your IP professional will then have had some background in it and have done it in a way that they know they were doing it right the first time.
Okay.
So you really, it's a cost savings to almost have it done if you're going to go the federal route for filing your trademark application, to do it with a professional the first time. Now, sorry, go ahead.
No, go ahead. Go ahead.
I was going to say, there are some cost savings too that you can do in helping you. You could do a trademark search the first time and give those results to your trademark attorney, or you could do some background work and a search for a patent and give those results to your patent attorney, because both your patent attorney and your trademark attorney would recommend doing those searches. And if you've already done some of the legwork, you've saved some of the cost that you would have incurred otherwise.
All right. Are there milestones or certain things that would trigger a business executive to start investing money in their intellectual property? So in other words, when is the go, no go decision made, or how should it be made, or when should they be thinking about starting to invest?
Sure. Now, with a patent, you may want to think, is this something that you want publicly known? Because patents are public documents. Anyone can see them. Is it something that you want publicly known and you want the patent? Or is it something that you want to keep within the four walls of your company and keep it as a trade secret? Now, trade secrets could also be such things as your customer lists or methods of creating certain things. Those you wouldn't want to spend money in protecting, because those are true trade secrets. But if you want to have a method of if the method of you manufacturing something is something that you see value in, and you think that it would be beneficial to perhaps license this method to another manufacturer or to industry resource, then you would want to think about patenting that and filing your patent application. You really need to think about how your product or how your method will be presented to the public, and whether it's something that you would see value in other people having. Or if you have a competitor who's going to do something very similar, then you would want to patent that as well. That way, if your competitor finds out about this, you can say, hey, I'm already here. This is my house. You can't enter my house. Whereas if the only way you get trade secret protection is if you can prove that someone actually knew what you were doing. And the way you avoid trade secret disclosures is just keep training your employees. That's a cheap way to protect yourself, is to train your employees as to what the agreements they've signed are, and the confidential disclosures. Now, as I've said, for the trademark side, you can just go about business with your trademark with not having it registered. Now, your trademark business name is going to have to be registered. Your business name is something you have to register with the state. But if you know that your brand is something that is going to be your platform brand, and you're going to be using it, throughout the country or through several states, then yes, go ahead and file that trademark registration. And the trademark process is typically around $3,500. So it's not a large expense the same way that a patent application is, but it's still a value to your company.
Sure. So for the business executives and owners, and I guess for that matter, investors and board members, as they try to assess the ROI on intellectual property versus maybe say other projects or other ways they could spend money, is there any suggestions for folks to try to assess the ROI on their intellectual property expenditure?
Sure. Brand recognition is a huge ROI. I mean, if you think about the Target bullseye, the second that you see the um, red circles, you know exactly what it is. And you know that that's a brand and a business that you can trust. So with trademarks, it's all about the customer facing business aspect to it. And that's how you can kind of assess your ROI on that. It's about the goodwill that you present to to the world. Now with a patent, it's about your ROI is in the competitive landscape. Um, are people of trying to do something different? Are you the only person with this one invention? Or are people interested in what you're doing and the licenses that you can get on this patent? Or is it part of your business that you can value and then sell in the future? There are businesses all the time that want specific technologies, and you can say, well, I have a patent on this, and unless you want this patent or you want my business, you can't enter this field or this area. So those are different ways that you can assess the ROI.
Okay. And if we go back to the beginning of our talk today, throughout your career, you worked inside organizations on legal matters, adjunct professor, now at an intellectual property law firm. So interesting career journey. You also moved across the country, went to college out on the East Coast. Were there any specific lessons that you learned that you wish you would have learned sooner?
Um, I I'm always as a lot of attorneys are a type A personality, and I wish I had learned to relax and let things just come as they come. As long as you put your hard work into it, things will usually come your way. And um, it's nice to know that I've had some fantastic mentors throughout my career who have just said, slow down and realize that you are smart, but you are not trained yet, and it takes time to be trained. And I've had some great mentors tell me that training is not 1 month thing. Training can be years, the same way that business development can take years, and you just have to wait and persevere. And once that I had that sink in, that just keep plowing through and doing your best, it will all come. You just have to give it some time.
Any lessons from the baking that you can translate into the business world?
Um, accept your mistakes and accept failure and keep trying again. As I said, I'm baking my way through this cookie cookbook, and which means I'm baking cookies that I've never baked before and I've never even attempted. And there have been some flops. There have been some times where I'm like, I can't believe I wasted a pound of butter, so much flour, so much sugar, and it's all going in the garbage. But then I don't let that deter me. I can be angry and frustrated with myself for, an hour a day or whatever. But then I get right back up and I try it again. Similar to I ventured the baking competitions at the fair. Like you said, for 10, 12 years, I can't remember exactly. And I've only placed 3 times, but that is hours of blood, sweat, and tears. And almost all of my friends, coworkers, husband know that the day the results come out is either a really good day for me or a day where you better have, ice cream and wine waiting for me at the end of the day because I did not place.
Yeah. Although you also still have the benefit of the children and the husband fighting over the ginger cookies, even if they're not your favorite.
Exactly.
Yeah. Say, on the talk today, is there one key takeaway that you'd like to leave the audience with regarding the topic of intellectual property? What would that be and why?
I'd like you to remember that IP is like a house that you're trying to protect everything in it. Whether it's the address or it's what you create in your house or it's the foundation of your house, because really intellectual property is the foundation of your business. Whether your business is creating or not, the brand that you create is almost an invaluable resource or that you have. And they're intangible assets. So I highly suggest that you really do consider what you're doing every step of the way. Make sure that all the departments in your business, whether it's 3 people that are working in a home office and that's what your business is, make sure you're all in communication about what those assets are.
And then Lori, while I mentioned your email address earlier, tell our audience how they can get a hold of you.
Really email, which is lyoung, YOUNG, at slwip.com. Otherwise, if you find me on LinkedIn, I'm always checking my LinkedIn profile. Those are great ways to reach me. In this virtual workspace, I more than likely screen my phone calls. So I would recommend reaching out via email or LinkedIn. And if you follow me on LinkedIn, I like to put random news articles and how they relate to intellectual property, even though it may not seem like it. So it's a great way to find out a little bit more about the intricacies of IP law.
Okay. And then just to be clear, I think what I heard is you do not share your baking recipes, correct?
I do not share the ones that I create, the King Arthur flour one. So I do have an Instagram feed directed just towards my baking. Those I'll share because they're King Arthur flowers recipes. But my state fair ones, the only person I've ever shared one of my recipes with was my husband's grandmother, who is no longer with us.
All right. Well, we won't press that issue then. However, tell everybody your Instagram site so that if people want to learn more about your cooking, they can go there.
Sure, it's at baking underscore all underscore the underscore cookies. And that's what my Instagram is. So I
Okay.
can also put it in the chat or
Okay,
the comments to this.
we'll put it in the chat too. Good point. So we'll put your email and your Instagram location in the comments field. So Lori, thank you very much for joining us. If we wanted to dive deeper into some of these IP topics, would you be willing to come back with us again?
Absolutely. And I would highly suggest as entrepreneurs that you take all of this, you digest it, and then feel free to reach out and ask questions because it's better to ask questions before you do anything. This is not an area where you want to ask forgiveness. You want to ask permission.
Yeah. All right. Well, thank you very much again for joining us, and we look forward to talking again and look forward to hearing about those blue ribbons at the state fair.
Thank you.
All right. Thanks.
Thanks.